for Canadian company hiring Korean company, and they're sending their employees here. It's a positive list. It varies depending on the category. Duration similar to the ones that we saw before. And then we have CETA, which has some elements of some treaties, but also their own. I guess the most similar one would probably be the Korea one, because it only applies to contractual service suppliers and it only applies to self-employed independent professionals. It only applies to citizens. I forgot to mention that for Korea it applies to citizens and PRs. And in this case, if you fall under the list of the contractual service suppliers or independent professionals, it's not just enough to have the education. Look at the list closely. They have other requirements for the contractual service suppliers. They have to have worked for that company that's sending them for at least 1 year, and they have to show 3 years of experience. And for the independent professionals, they have to show 6 years of experience in that occupation. And this is for a short-term or medium-term entry of up to 12 months. Then we talked about GATS, 3-month entry, very specific to when a Canadian consumer enters into a contract with a foreign firm that's sending someone to do certain services, and again, the list of professionals is very limited. And then we talked about the global skills strategy, nothing to do with the treaties, an option to bring Canadians for 30 days or less, or 15 days or less. There's 2 programs, or 120 days or less if they're academics. So that's kind of like an overview of what we looked at. Again, I know it's a lot of information, but let me know if you have any questions. And again, always, whenever you have someone, every time I'm going to do a consultation and I see citizenship Korean, I'm like, in addition to what I want to cover here, I might as well take a look at the treaty and see if it's someone who has a job offer in Canada, then we might as well kind of like discuss this. And if it's someone who doesn't have a job offer in Canada, as part of the consultation, let's say it's a Korean national who's saying, I just want to look at my immigration options. I talk about express entry, I talk about the federal programs, I might talk about the provincial programs if they have some kind of like tie to a province, but I might throw in that, well, if you happen to work for a company that is sending you here, you could, get your work permit, or if you are a self-employed individual, then you might have this option as well, but you need to have pre-arranged services that you're providing here. Okay, so seeing that there are no questions, and I'll get into some of the nitty-gritty practical considerations when we're putting these types of applications together. So if it's an application that's filed at a visa office, consider the general and country-specific checklists. Some countries require police clearances, some countries require birth certificates. And again, we've seen refusals in the past because we don't include this. Best case scenario, they just simply ask for an extra document that wasn't there. But in other cases, it does lead to refusals, and you have to be careful to meet that. If you're doing it at the port of entry, a lot simpler. We just put together the package that we want to have. We don't have to worry about the forms, and we don't have to worry about country-specific checklists in that case. Cater the application to the client. That's, something that I think everyone knows, but not everyone really follows. I find a lot of people are pretty loose in terms of like providing like the same checklist to everyone. They kind of like put the same type of application, and they don't take into consideration the client, some of the weaknesses in their case, which could be individual to them. They might have refusals in the past. There might be issues to ties to home country. They could be specific to the employer. If it's a new employer, in addition to the registration documents, you might want to include some financial documents, because an officer might not be convinced that this employer is going to be able to pay for the salary of the foreign worker or for the services of the foreign worker. If it's a large employer, then I don't really care even about including a certificate of registration of the company. If it's a mid-sized employer and people don't really know much about it, but it's been incorporated for the last 5 years, 10 years, I'll include the registration, but I don't care so much about providing financials because, this company has obviously been in business for a while. So it is very specific what we do. I'm kind of a view that like sometimes I like to collect as much information as possible and sometimes documentation as possible, and then I decide what to include, what's helpful, what's not, what's needed, what is not. So as we were talking about, the legitimacy of the employer is going to be more important in IMP than when you do an LMIA work permit under the temporary foreign worker program. Why? Because when you do an LMIA, Service Canada has gone through all of this. They put you through the ringer in making sure that they have enough financials to pay for this employee, that they've met whatever requirements they need to meet. At the time that you apply for the work permit, I only care about showing that the worker is eligible for this and that they're qualified for this job. I don't care about the employer because I've already proved that to a different government organization. Okay. And as I said, like documentation will depend on the size of the employer, the reputation of the employer, and I've provided a few things that we sometimes tend to include. Registration documents that shows how long the company has been operating for, what kind of company it is, financials, if it's a relatively new company, or for some small companies we include that, and sometimes I like to provide commercial lease or proof of title. Again, mainly for new companies to show where the employee is going to be working, and stuff like that. Sometimes we have employees that have to be working at different offices within the province and stuff like that, so we might provide evidence of that. Just because I say that the employee's qualifications are crucial doesn't mean that the legitimacy of the employer is less crucial. It's important as well, and again, this really varies depending on the employer that you have, how much you want to document it. For the employee, the education is going to be mandatory. As you saw in every single one of these free trade agreements, they're about professions. They're about specific occupations. If you're sending an economist and that person does not have a bachelor's in that, you're not going to be able to fit them under this. You need to include like grades and diplomas. That's the minimum that you have to include in a lot of these applications, and we always get those. Sometimes we have a little bit of a fight with our clients saying just like, oh, that's such a hassle to get this. I have to like ask my university. I've been out of I've been out of school for the last 9 years. We need to provide them. You could have been an engineer for the last 20 years and we can get letters. Part of the things that you have to include for, let's say, a Canada-Chile FTA agreement is proof of your education. It doesn't matter how long you've been practicing for. So that's important. We have a lot of clients who have like extra certificates. So it'll be just like, in addition to being an engineer, they're an expert on, I don't know, like batteries, an expert in this and that and that. And if that's relevant to the job that they're going to be doing in Canada, I'd like to throw them in. Again, it shows that this person has like a unique skill set and expertise. Not part of the test that I'm looking there, but like it just makes the application stronger. If it's not relevant to the occupation here, then I'm probably not going to include them. And if it's a lot of certificates, I mean, sometimes you have these people who just they get certifications like every 6 months. They might have 10 of them, but they're all like in a different language. Do I really want to have that translated and put the client through the expenses of doing that? Probably not. I'll just decide what's important, and maybe just degrees are important. Work experience, so as you saw, is not always required to be documented for these kinds of applications. A lot of FTA professions can be new graduates, but in some cases, you do have to document it. And if you have to document it, obviously there's no way around it other than getting the letters. And then what those letters are going to look like, very similar to what we do for other types of applications, including permanent residence applications. Letters should have the dates of employment. If it's continuing, then say from this date to this date. The letter should have the hours, because that way you can show the person has been full-time or not. They should have the duties, and the duties are going to be clear, are going to be very important. Again, we have a lot of input in these letters. I like to make sure that the duties are consistent. If I have to prove that this person has 3 years as an IT consultant, then I'm going to make sure that whatever letters we provide are consistent with the NOC that we're claiming, be it NOC 2171, for instance. Many times I tell the clients, provide me the list of duties, provide me this information, I'll prepare the letter, I'll prepare kind of like a draft that you can input more information. So dates, duties, hours, pay, and benefits. Again, the benefits is something that we just include anytime, but the pay is going to be important. And I think that's basically it, what you're going to have in those confirmation letters. They're very important. If it's an application under CETA and it's someone who's self-employed and you need to show 6 years of work and they've been self-employed for the last 12 years, then you're going to have to include more information. Registration of this person's company, letters from partners, employees, third parties that can confirm the work that they do and all that kind of stuff. So you're going to have to treat that application differently. And again, this all comes back to the whole catering the application to the client, not just submitting the same type of application. What about situations where it's just a straight, let's say, NAFTA engineer? I don't have to prove any work experience, but my client has been working for the last 5 years. What I normally do in those cases, if it's existent, I document it. I don't worry too much about it because at the end of the day, they're really going to be focused more on whether they have the degrees or not. Obviously, it's important that the letters that you're providing are not inconsistent with what you're claiming, but I like to document it. Again, I like to have more. I'm always of the view that if it's reasonable and it's possible to get it, I might have it. Now, if the client says, well, no, I've had like 5 different employers and it would be like a hassle to get letters, I would probably say, okay, let's get a letter from your current employer. That might be like the easiest to get, and don't worry about the others. Or if I find it's like going to be like a lot of work, then I might actually not do it. But again, this is a discussion I have with the client. I do like to document it if possible. Language. So I think we talked about this earlier. If they've written the CELPIP or the IELTS, and those are the 2 ones that for immigration purposes are accepted, so I don't really use others. If they have it, and it's at least a CLB 7 on everything, I tend to include them. I mean, it's something that's going to be helpful. If the officer has any doubts whether my client is qualified to do this job or not. If they don't have them, I'm not really going to necessarily ask them to go chase it, but I tell them that it could be requested and it should be provided if it's requested. So sometimes have the client be aware of that, be prepared, but I'm not really, this is not a situation where I'm going to tell them you should go write the test just so we have it in case they ask for it, because I know it's a lot to ask from a client if it's really not necessary. The employment contract or offer of employment. So this is going to be a very important document. It's a document again that we have some input. We don't, if it's a contract, and you've heard me say this in other courses that we've done before, I don't draft it. I'm not an employment lawyer. I'm not a contract lawyer. I'm not an expert on that. If they have their own template, that I can review it to make sure that it meets the requirements for immigration purposes, only for immigration purposes, I make that disclaimer, but I'm not going to be changing anything that has to do with termination clauses or clause or I don't know, like the applicable jurisdiction clause or things like that. But I do like to review them. Sometimes you have employers who are a little bit different. They don't really have like a standard employment contract, and they don't really have like a standard offer letter. So we prepare those. I don't feel uncomfortable preparing an offer letter that doesn't have any of the labor law stuff, but just the things that I need. And then those have to include the proposed employer, so information about the proposed employer in Canada. I mean, that normally would be in the letterhead and saying, I don't know, ABC company is offering you the position of blah, blah, blah. So you're going to have the position title. You're going to have the duration. I would recommend that you don't put permanent or indefinite duration when you're doing a work permit application of this nature, because again, they're supposed to be limited. There's a temporary entry. You might be able to get away with not putting a duration, but I like limiting it. And if clients say, well, what should we start with? I normally say, let's put 2-3 years, whatever you want. But I do recommend that you put a limited duration. Otherwise, you might get some pushback that, well, I mean, this is a work permit. How am I not convinced that this person is just coming to stay here indefinitely? Which is a silly thing to say, but I mean, again, from bad experiences with officers, you always learn, or from hearing with other people, the issues that they've had. The salary is going to be mandatory, and the benefits for the offer are going to be mandatory, both of them. If there are no benefits, then list no benefits. If the benefits is only vacation, which a lot of people sometimes don't think that that's a benefit, then you have to include that there. And the duties. Duties need to match the NOC. So if you're claiming an economist, look at the NOC, make sure they match them. Obviously, it's based on what the person is going to be doing. For 2 reasons. One of them, like, you have to be honest in these documents, and the other one, if your client is the employer, or the employer of your client is going to could be subject to compliance reviews. And if they go to their office or they start looking at what this person does and it doesn't match what they put in the offer, then that's going to be a problem. So it has to be based on what they do, but it also has to be based on what the NOC says for that profession. And you should have screened before to make sure that those 2 are consistent. Educational qualification. This is something that's in the program delivery instructions, but I normally don't include it. I don't normally say this is a position where you need to have this and that, but a lot of employers have schedules to their offer letters that say these are the requirements for this job, or they might have a schedule which is the duties, another schedule which is like what the requirements are. It doesn't, if it's there, I'll include it. That's not an issue. If it requires licensing, so for instance, if we're bringing a vet, I'll put that it requires a letter of approval from the College of Veterinarians of Ontario, and that this has been obtained. And then obviously I'll have to include that as part of the application. If it's an engineer, for instance, one of those that it could be what they do could be licensed, or what they do could be non-regulated, so they don't need a license, I'll put that in the letter. So in the employer offer, I would probably say just like, this type of work is not regulated by the province of Ontario, and you're not required to apply to become a member of the College of Engineers of Ontario, for instance. Something like that would be in the letter. And as I said, I don't draft employment contracts unless, I mean, you can if you're a commercial or labor lawyer, and but I do assist with job offers. If they don't have either and I have to draft it, then I do the job offer. I feel comfortable doing that. But again, I warn them, this is just for this purposes. If you want to protect yourself in case this person quits, in case this person steals property, for termination and things like that, you might want to consult a lawyer for those kind of things. So this is the employment contract if you have a situation where they're being independently employed, okay? If it's an independent contractor, it's probably going to be similar. So you're going to have similar elements there as the ones that you have there. Now, if it's a third-party contract situation, so again, to describe it, you have Colombian firm hired by Canadian consumer. They're going to send an engineer here to do a project for 8 months at some site. So in that case, the Canadian company is not really going to be preparing an offer of employment for that person. You have to document different things. So there has to be a contract between Canadian consumer, let's say it's a Canadian company, and Colombian company for the services that are going to be provided. That I never get involved with in the preparation of that. I could maybe review it and provide some input, but like that really doesn't affect immigration much. I mean, I have to make sure that it's not inconsistent with what we're claiming. It might be that the services that they're describing are services that not the scope of what an engineer or an architect does. And then it's hard to say, well, why are you bringing an architect if this has nothing to do with architecture? But this type of commercial contracts, they're way over my head and have nothing to do with immigration. So they normally have been executed already by the time that I'm engaged. So I normally say, okay, I know that you're bringing this engineer. Can I get the contract that you have with the engineering firm in Colombia to include in the application? So I normally don't provide any input there, but that's going to be a mandatory document in those kind of applications. And then I want to document the employment experience between the foreign national and the foreign employer. So if that Colombian company is sending someone, I need the contract between the Canadian consumer and that Colombian company, and I also need to show that that person is an employee of that foreign national who's Colombian is an employee of that Colombian company. Normally I do that through confirmation letters from that employer. If there's a contract for that employment, I might include it as well. Again, it's a judgment call. The employment letter might be enough. The contract might be in a foreign language. I think it's too much to have that translated. If they have if they have pay stubs for the last 4 months, I like to include that as well. That's a way to show employment. If this was through through CETA, in addition to the contract between the Canadian consumer and the European company, we need to show that our employee has been working for that European company for at least 12 months. So that's a little bit more. The letter needs to show that, and I probably will try to get pay stubs for those 12 months as well to prove that. So these are 2 mandatory documents that you're going to need in those situations. If it's a case of a self-employed person, so we were talking about before when Priya was asking her question, we're going to have to do prove that this person has their own registered company, that they're coming here, explain how the billing is going to work, that it's an independent thing. So you might have to provide evidence of that as well. As if you're doing an out-of-country application, you're going to be filling out the forms. So you're going to be doing employment history there, and this is just applies in general. You know that the form has space for like 3 employers, so if they had more than 3